want to say at the outset that I'm delighted to be here in Warsaw together with my wife, Željka. We arrived yesterday from Zagreb, and it's a great honor for me and a privilege to be able to address this distinguished audience. I want to recognize the Deputy Foreign Minister. Thank you for coming. Esteemed judges of the Constitutional Court, the Croatian Ambassador to Poland, and other guests, thank you for coming. And I'm also very pleased to see so many young faces in the audience. Hopefully what I have to say won't put you to sleep, but will spark some interest in some basic questions on the nature of law and justice. There's much I want to share with you today. I've been told I have about 45 minutes, so I've tried my best to prepare this lecture. It will be a reflection on the fundamental questions associated with law and the rule of law, how when these questions are not properly understood, we can have also abuses of the rule of law for different political reasons. So when one does a Google search and enters the words Poland and the rule of law, headlines such as EU launches infringement procedure against Poland, or Poland digs in over EU rule of law pressure, or independence of judiciary is under threat in Poland. Europe confronts Poland over its trampling on the rule of law. These are some of the headlines you can find on Google, and it all sounds very alarming. Is Poland becoming a threat to democracy and the rule of law? Should we have confidence in the judgment of European institutions concerning these disputes? These are the same political bodies in Brussels and elsewhere which considered the prominent Italian philosopher Rocco Buttiglione unsuitable to serve as a commissioner in 2004. I would suggest to younger members of the audience to Google his name as well, Rocco Buttiglione, a very prominent Italian philosopher. While at the same time, former communists from Central and Eastern Europe have been welcomed uncritically as commissioners and in other high offices in Brussels since 2004. And the Polish philosopher and now member of the European Parliament, Julia mentioned him earlier, Richard Legutko, makes this observation in his book, The Demon in Democracy. The former communist leaders and functionaries have received very good reviews in the West, as opposed to avowed anti-communists who have been treated far less kindly. I think this is an interesting observation, and I agree with my colleague Richard Legutko. My own intuition is that Poland is being harshly treated today, partly because it has dared to question the supremacy of European law, but also because the current government, Law and Justice government, advocates a vision of Europe which includes respecting our common Christian identity. This is simply unacceptable to the secularist elites who have gradually assumed control of European institutions and have no patience for dissenting views. But the Polish people have a visceral understanding that dissent is sometimes necessary in order to achieve justice. Make no mistake about it. People are closely watching how the current disputes between Brussels and Warsaw, but also Budapest, will be resolved. It is not an overstatement to say that the future of Europe is in the balance. Poland, like my own country of Croatia, was forced to undergo the social experiment commonly known as communism. It is necessary, I think, to make a few remarks regarding this ideology because its legacy still haunts the countries of Central and Eastern Europe. I believe that the reasons for the failure of communism have still not been grasped by Western elites. And this remains one of the underlying causes for disagreements between older member states and those that joined the EU at a later time. There is clearly no consensus on the nature of freedom and basic principles of justice, nor on what European values mean. I will speak more on this later, but first would like to elaborate on the deeper causes for the dramatic collapse of communism in 1989 and what lessons we can draw from this historic event. The biographer of St. John Paul II, George Weigel, has argued that the revolution of 1989 was primarily a revolution of the human spirit, inspired and reinvigorated by the Catholic faith, which proved to be the irresistible force that the communist regime could not finally withstand. Weigel poses the question, when did the revolution of 1989 actually begin? Who lit the match that ignited the flame? He offers one possible answer found in the chronology of world events published annual by the journal Foreign Affairs, a very highbrow, elitist magazine, which stated the following in its chronology. June 2nd to the 10th of 1979, Pope John Paul II visits Poland, celebrates his first pontifical mass in a communist country, and meets with political leaders. One could argue that Poland would never be the same country after the first papal visit in 1979. Metaphorically speaking, the Polish people began to cast off the chains which had been put on them by the totalitarian regime. I think Weigel is correct in his view that a moral and cultural revolution preceded and in fact made possible the political changes in 1989. This is what one could say was happening under the surface, below the surface, in Central and Eastern Europe, and was decisive in bringing down communism in a peaceful way. It's rare in history that we have revolutions of that magnitude that are peaceful, and movements towards greater freedom happen rarely in human history. So we should carefully analyze what exactly happened in 1989. The spiritual dimension in human events is typically disregarded by social scientists in academia. And as a result, their explanations miss the distinctiveness of the unique historical upheaval. I say unique because it is indeed very rare in human history that one can observe such a sudden increase in freedom. But the change, or to use the theological term conversion, which made the revolution possible, was slow and gradual and remained undetected by the politicians in power. This undetected change or conversion of individual persons affirms St. Augustine's basic idea, elaborated in his epochal The City of God, that the real course of history goes through every human heart. This is the Christian view of reality, that each person has a unique role in God's providential plan for humanity. This is history seen through the prism of eternity, sub specie eternitatis. The vast majority of the interpretations offered by policy analysts and commentators tend to focus on the political personalities like Reagan, Gorbachev, on the economic issues or diplomatic process. They certainly have elements of insight and truth, but are in the end unsatisfactory because none of them take sufficient account of the why and how behind the moral revolution that preceded these changes. I would also like to mention Francis Fukuyama's solution to the puzzle of the late 1980s. In his view, history did it, or rather the revolution was inevitable all along. His essay and later book, The End of History, captures the popular and media reception of this hypothesis. We, the West, had won because we were right from the beginning, or because we were on the right side of history. Fukuyama's Hegelian explanation sparked much debate, and to his credit, reaffirmed that ideas do matter and do influence the course of history. He quite reasonably suggested that the West was in danger of missing the main storyline of the late 20th century, and that the dramatic events of '89 could not be explained by theories of economic determinism or power politics. His end of history theory, however, has no place in it for the reality of evil. The 20th century has clearly shown that evil is an inherent part of the human condition and will always find an organized social expression. In his analysis of why communism finally failed and collapsed, Pope John Paul II mentions the inefficiency of the economic model that was flawed and failing people in Central and Eastern Europe and the violation of basic human rights. But I will quote the Holy Father. This is from Centesimus Annus. He says, "The true cause of the new developments was the spiritual void brought about by atheism. Marxism had promised to uproot the need for God from the human heart. But the results have shown that it is not possible to succeed in this without throwing the heart into turmoil." End of quote. And this is the key point, my first key point. The West has forgotten that politics is a function of culture. Politics is, so to say, downstream from culture. It's a reflection of what's happening in the wider culture as such. And at the heart of culture is religion. We should keep this truth in mind today as well. Next, I would like to clarify what the rule of law is, properly understood. I will argue that certain fundamental principles of justice precede written laws and require a metaphysical grounding. Metaphysics is crucial in defining the basic goods which the rule of law should serve and protect. But it also informs our assumptions about what is right and just in our relations with each other, what we owe to each other. In the classical definition, this is sum cuique tribuere. This is something that even pagan philosophers were arguing before the time of Christ. Metaphysical considerations are primary and transcend political philosophy. And I would add that the New Testament was not meant as a substitute for metaphysics, as the things of Caesar remain properly Caesar's. In fact, there is no inherent contradiction between faith and reason. They are rather complementary. However, the city of God is not the polis of Aristotle and Plato. As one scholar of Thomas Aquinas explains, the New Testament provides no systematic guidelines for the organization of human society. How are human beings to act in this or that situation? What is the role of law in human society? To help answer these questions, the Christian Church of necessity turned to philosophers, to those who systematically reason about morals, politics, and law. So we shall also turn to the philosophers. As Aristotle taught, there is a hierarchy in the order of sciences. Metaphysics is more foundational than political or legal philosophy. Metaphysics examines first causes and tries to explain why things are as they are. True knowledge then leads to wisdom. Politics is the art of applying these first principles in concrete circumstances. When there is confusion about these principles, we can expect deeply flawed decisions by judges. For example, in the United States, the Supreme Court ruling of 1992 in the landmark case Planned Parenthood versus Casey stated the following. This is from the majority opinion of the Supreme Court. "Liberty," I quote, "is the right to define one's own concept of being, of the universe, and of the mystery of life," end of quote. But can this really be the basis of human freedom? The American philosopher David Schindler wrote a book called Freedom from Reality, the diabolical character of modern liberty. And it's a great critique of the deceptive and ultimately self-subverting character of our modern understanding of freedom. He demonstrates that the very mechanisms that intend to protect freedom render it completely empty and ineffectual. His basic presupposition is that an adequate approach to the notion of freedom must include three features. It must understand freedom primarily in ontological terms. Second, it must recognize an essential connection between freedom and the good. And third, it must see relation to the other as an intrinsic part of the meaning of freedom. He is certainly correct in arguing that modern man has separated what is meant by freedom from a substantial notion of the good. And we have in fact turned it thereby into a substitute for the good. This substitution involves a fundamental logical incoherence. It both expresses and causes patterns of fragmentation and in fact contradiction. One could respond that we live in a pluralistic society with competing worldviews of the good. We don't agree on what is good. And thus there is no consensus on how best to teach basic moral principles. This is the dilemma which inevitably arises in a culture where philosophical relativism is dominant. I will next examine how one liberal thinker proposed to resolve this problem. The philosopher John Rawls, he taught for many years at Harvard. His Theory of Justice, first published in 1971, was a very influential book. Students today of political science and social sciences in general are almost always familiar with Rawls and his writings. He's one of the leading luminaries or authorities in liberal opinion. In his book, Political Liberalism, he asserts that law should avoid passing judgment upon certain practices. Which moral judgments are true, he argues, is not a matter for political liberalism. So he puts these aside. Therefore, law should not limit human autonomy on the grounds that a particular concept of human flourishing is more truthful than others. Rawls offers an alternative to truth-based theories, which involves the establishment of an overlapping consensus, that's his term, in pluralist societies. This consensus should be based on agreement about the just conditions for collaboration among reasonable individuals in a liberal democracy. He argues that instead of attempting to determine which of the competing religious or secularist doctrines is true, democracies ought to focus on establishing, as he says, a liberal political concept that non-liberal doctrines might be able to endorse. That's his task, of providing a minimum for consensus. According to Rawls, truth should be supplanted as the measure for correct law by an idea of the reasonable. Therefore, the good and the true are different from the reasonable and the right. People can hold different views on a range of questions, but this does not mean that all views are equally reasonable. There's an obvious weakness in his proposed solution because personal autonomy is the implicit good. He doesn't say this explicitly, but it's implicit. It's the implicit good that overrides other considerations, which means that in the end, he's not presenting a neutral position. Personal autonomy trumps other considerations. I would also like to address another part of his theory, the concept of the original position behind the veil of ignorance. This is very interesting how he imagines the original position behind a so-called veil of ignorance. He imagines an abstract state in which you know nothing of yourself and your natural abilities or your future position in society. You know nothing of your sex, race, nationality, individual tastes, talents, etc. Starting from this original position, Rawls contends that the most rational choice for the parties in this original position are two principles of justice. He finds them non-controversial. We all must recognize these two basic principles. The first guarantees the equal basic rights and liberties needed to secure the fundamental interests of free and equal citizens to pursue a wide range of conceptions of the good. So, fundamental equality of basic rights and liberty. The second principle provides fair equality of educational and employment opportunities, enabling all to fairly compete for powers and positions of office. And it secures for all a guaranteed minimum of the all-purpose means, including income and wealth, that individuals need to pursue their interests and to maintain their self-respect. I would argue that Rawls's theory lacks an adequate concept of society and the human person as a naturally social being. In this sense, Rawls is a typical modern philosopher. He rejects the classical understanding of man as zoon politikon, as Aristotle says, a social being by nature. His understanding of free and equal citizens is a result of a political constructivism, which makes an abstraction from what persons naturally are as social beings, and therefore as citizens. In reality, citizens properly understood are also parents, family members, children, including unborn children, neighbors, partners in business, and other forms of exchange. He equates the family, Rawls, to all other forms of voluntary associations. Listen carefully. He equates the family with other forms of voluntary association. As he said, churches or universities, professional or scientific associations, business firms, labor unions, etc. This, however, appears to be quite unreasonable. It contradicts basic empirical facts about the reproductive nature of the marital union and about the family. The natural family is not voluntary. Nobody has chosen his parents or his family, nor has he chosen to be born. And parents do not choose their children. The fact is that the family precedes and exists independently of the state. It is a pre-political and social reality and must be recognized as such. Any well-ordered society is subsidiary to and must be respectful towards what naturally constitutes its citizens as social beings. It's a basic truth. Shouldn't be controversial. In other words, it is reasonable to expect that the state protect the family. There's an even bigger problem when one considers the issue of abortion, when one applies Rawls' own principles. In the course of developing his ideas on justice, Rawls discussed abortion in relation to the idea of public reason. How should we think about this issue? He described opposition to the right of abortion, at least in the first trimester, as unreasonable. That was his own position. In Political Liberalism, he famously inserted a footnote in which he endorses a duly qualified, he says duly qualified, right to abortion during the first trimester of pregnancy. He makes acceptance of this right a litmus test for the reasonableness of any comprehensive doctrine in a pluralistic society, what's allowed in the public sphere, whether the doctrines are religious, philosophical, or moral. In his characteristically Kantian way, Rawls defines persons as moral persons, those who can exercise rationality and moral agency. Those are persons. This definition seems to exclude not only unborn children, but all children up until the age of reason. Children up until the age of reason are not held accountable for their actions, and we understand why, because they're not fully capable of using their reason as human beings until they reach the age of reason. According to Rawls, we must imagine a situation in which we do not know anything about our own future circumstances in society, And he says self-interest can motivate individuals to look out for what they themselves would want, and he says that that is reasonable. But following this logic, wouldn't it be reasonable to insist that every human being has an inalienable right and interest to be born? Because this is a precondition for every subsequent right. Only people who are alive can consume other rights. It's a precondition, and it comes first. Rawls was unable to resolve this obvious problem in his theory. I will now move on to discuss the classical theory of natural law as a foundation for the rule of law. So, natural law claims that there is an objective moral order in the world and that human beings by their very nature can discover the truth through reason. Therefore, the rule of law must be in accord with practical reason and fundamental moral principles accessible to all human beings. So it argues that this is universal, there's universal application. The first of these principles is do good and avoid evil. That's the first basic principle. Then followed by thou shalt not kill, thou shalt not steal, thou shalt not bear false witness, etc. Every human society, not only those belonging to the Western tradition, should recognize these principles as fundamental to social order. However, today, natural law, lex naturalis, is almost incomprehensible due to an understanding of nature that is no longer metaphysical but only empirical. Therefore, the word nature no longer has clear moral implications, and this creates a sense of disorientation, especially for younger generations. Both the fundamental principles that constitute natural law, they are both unbreakable and contingent norms that do not depend on the will of the legislator, nor on recognition by the state. They are, in fact, norms that precede any human law and are not subject to modification by anyone. So it doesn't matter what a majority of judges thinks or a majority of MPs in Parliament think. These norms do not change. And Cicero recognized this when he talked about eternal law, eternal principles that constitute justice. Natural law thinking emerged in the ancient world in the context of a certain teleological conception of reality. Natural law is binding according to the earliest Stoic version because it tells us how to move toward our final end. That is, how to actually become what we are potentially. I've mentioned Aristotle as one of the greatest authorities in arguing that human beings have the capacity to discover moral truths and to recognize what is objectively good. And we see that this theory did not originate with Christianity, but existed before the coming of Christ. The focus was on the good and taught that human freedom was authentic if it was under the rule of reason. It was surely not conceived as pure will or as a tool to achieve our desires. There's some basic principles I just want to mention in passing that I think most people agree on today in liberal democracies concerning the rule of law. First, rules are promulgated and are clear and coherent with respect to each other. Second, rules are prospective rather than retroactive and not impossible to comply with. So they're, in a practical way, reasonable, and we can expect citizens to abide by them. Rules are also sufficiently stable to allow people to be guided by their knowledge of the content of the rules. And those charged with the authority to make and administer law are accountable for their own compliance. So no one, even the head of the constitutional court, is not above the law, but must comply. There is also a recognized division of responsibility in administering the law. No one, for example, can simultaneously be judge, witness, public prosecutor, and public defender. So there's a division of labor, so to speak. By conforming to these principles, law makes a vital contribution to freedom from unjust coercion. We are all subject to the same law, and our obedience to the law means that we are not subject to the arbitrary will of those wielding political power. We thus enjoy liberty under the law. This is what the second U.S. President, John Adams, had in mind when he distinguished between the rule of law and the rule of men. One of the purposes of law is to inform us of our obligations, but it also serves the purpose of limiting political power. This is very important in Central and Eastern Europe with the legacy of communism. Good law limits political power. Good constitutional law clearly defines the powers invested to the different branches of government and restrains politicians in exerting power over the population. As Thomas Aquinas teaches, law is ultimately an act of reason and involves more than just the stability of rules and their consistent application. If the rule of law is to be just, it requires a more solid foundation. The legal scholar Lon Fuller, for example, insists that the rule of law incarnates an inner moral logic, inasmuch as there are certain conditions of reason that law must meet before it is understood as legitimate law. In other words, there's principles that allow us to distinguish between just and unjust laws. It does not primarily mean that those responsible for administering the law must simply uphold established rules and procedures. Rule of law, according to Aquinas and Aristotle before him, is acting according to the precepts of reason rather than from our passions. Thus, law should determine in advance what judges should decide. There remains nonetheless the role of judges to exercise their judgment in order to resolve inevitable ambiguities of meaning and to reconcile different laws. Practical reasonableness, therefore, is a basic good and must be respected under the rule of law. And we know that it is prudent, in fact, to separate political power among the different branches of government, and that an independent judiciary is vital for the proper administration of the rule of law. However, I would like to draw your attention to a potential threat to our current political system of self-government. I have in mind the phenomenon of judicial activism, or as some have even described it, judicial tyranny. This occurs when judges misuse or abuse their constitutional authority and impose radical social changes through deeply flawed rulings, thereby bypassing the democratic process. In other words, when there is not enough political support on an issue, the courts implement a policy in the name of the rule of law. One obvious example that I will refer to is the U.S. Supreme Court's Obergefell decision regarding marriage in 2015. The court's most fundamental error was its failure to interpret and apply the Constitution to the case at hand. It simply offered amateur philosophizing about what marriage should be and what freedom must become. Chief Justice John Roberts opened his dissenting opinion, it was a 5-4 decision, by noting that the Supreme Court is not a legislature. Whether same-sex marriage is a good idea should be of no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. He continues, there is, after all, no companionship and understanding or nobility and dignity clause in the Constitution, because these are principles that the majority opinion invoked in their judgment. This decision was, in fact, I would say, an act of will. The right which was declared has no basis in the U.S. Constitution or in precedent. By usurping the power of the legislature, the majority acted on its desire to remake society according to its own understanding of the nature of injustice, in their words. The late Justice Antonin Scalia offered this observation, I quote, "Hubris is sometimes defined as overweening pride, and pride, we know, goes before a fall. The judiciary is the least dangerous of the federal branches because it has neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm." End of quote. With each decision of ours, that takes from the people a question properly left to them, says Kalia, we move one step closer to being reminded of our own impotence. In other words, the judges had bypassed the democratic process and imposed their own view on marriage on the entire population. And this is an obvious, I would say, abuse of the judicial power in order to get wanted results that can't be won in the political process. I mentioned U.S. cases. I want to go now back to Europe as I move towards the end. My own view is that the EU has evolved into an entity today which no longer could be recognized by its founders, like Robert Schuman, Konrad Adenauer, and Alcide de Gasperi. One striking sign of this change in Europe was the controversy over the invocatio Dei, or mentioning God, in the draft EU constitution. This was a very interesting debate about 20 years ago when the leaders in the EU wanted to provide a new constitution that would apply to the entire European Union. This is how one legal scholar, Joseph Weiler, from the United States, described the debate. I quote, "In progressive liberal circles, the demand that the preamble of the Constitution of the European Union include a reference to God and or Christian roots of Europe has been met with derision and even contempt. Such a reference, it is said, would run afoul of the common European constitutional tradition of state neutrality in matters of religion. It would also offend against Europe's political commitment to a tolerant, multicultural society. But the opposite is true," he says. The opposite is true. A reference to God is both constitutionally permissible and politically imperative. End of quote. These are strong words indeed, and beg the question, how did we get here? If my earlier assertion that politics is a function of culture is correct, we must examine what changes have taken place in European culture and how these changes have influenced our politics. It is beyond the scope of my lecture today to provide a definite answer to this question, but in the remaining few minutes, I will try to raise a few points. First, we have radically changed the way we perceive human nature and our place in the universe. The classical understanding of man as a unity comprised of body and an immortal soul is no longer widely accepted. The denial of the soul is, of course, nothing new, as we have had materialist philosophers making their arguments for centuries. One of the most influential was certainly Thomas Hobbes, the English philosopher Thomas Hobbes, who aimed to provide a new justification for the state based on the will of the sovereign. The immaterial and immortal soul had no place in Hobbes's entirely material universe. For materialism, the soul is not necessary. For in his own words, Hobbes says, "Life is but motion of limbs, and all motion is mechanical." His materialistic anthropology led him to reject natural law and the idea that there are universal norms which bind every human being. Therefore, Hobbes invented natural rights, which are, as the philosopher Alistair MacIntyre has argued, complete and utter fictions. But it is only by viewing the origins of these natural rights in Hobbes that we will see how indebted we are to him. So I'm referring to Hobbes by intention because I believe his influence, even though he was living in the late 16th century, his influence goes very deep. And in fact, I would argue, is very fundamental to understanding how the EU understands power and law. Rights, in the modern sense, presuppose the myth of the Hobbesian pre-social state of nature and its attendant amoral chaos. This is his description. This is how Thomas Hobbes describes the pre-political condition of man, before we get government and institutions, etc. It's the kind of a primal condition. He says, and because the condition of man is a condition of everyone against everyone, homo homini lupus est, so man is a wolf, in other words, one towards the other, in which case everyone is governed by his own reason, and there is nothing he can make use of that may not be a help unto him in preserving his life against his enemies. It follows that in such a condition, every man has a right to everything, even to another's body. End of quote. That's Thomas Hobbes. Everyone has a right to everything in this original human state of nature. His imagined condition is essentially a state of lawlessness. So this reality that Hobbes is imagining is a state of lawlessness. Why? Because there's no one to implement law. There's no institutions. And for him, it's a state of essentially war, lawlessness. Indeed, a miserable condition of constant violent struggle among persons who are all following their own legitimate desires. Everyone's following their own legitimate desires. It's natural. Thus, it is only the sovereign who can be the source of norms, and the law is subordinate to the power from which it derives. Hobbes's political theory is a logical consequence of his anthropological assumptions. Consequently, if all norms are artificial and a result of some contract, the social contract, politics inevitably becomes nothing more than a pragmatic instrument for achieving maximum satisfaction of individual desires. Whether the sovereign is one person or many persons, whether we live under a monarchy or a democracy, there is no law above the human law, according to Hobbes. I submit to you that today's EU in many ways functions along Hobbesian principles. And this is the reasoning behind when there's anniversaries in Europe celebrating the project of peace. And in fact, Europe has avoided major wars until Croatia was attacked in 1991 and more recently Ukraine. But most of Europe has lived in peace since World War II. And it's mostly along these lines that must be avoided at all costs, as Hobbes says, and power must thus be given to a sovereign whose job is to protect us. Secondly, our modern society views man as homo economicus, the human person as the ultimate pleasure calculator. This creature seeks only to maximize personal gratification. His actions are focused on the calculation of costs and benefits from a narrowly self-interested perspective. This same creature will avoid and evade rules if he can, and will tend to abide to them only if it is in his material interest to do so. In short, Homo economicus is somewhat of a sociopath to whom the idea of authentic freedom is completely alien. This philosophical viewpoint is closest to a crude form of utilitarianism. That which is good is what provides most people with pleasure, gratification, and utility. And each person's idea of what is pleasurable is purely a matter of subjective preference. Interestingly, such an anthropology of man is almost as reductionist as that promoted by Karl Marx. But this philosophy that I'm referring to has outlived Marxism, at least in Europe, and therefore is more relevant to what we're discussing today. But it is also why we must draw the proper lessons from the collapse of communism in 1989. So, ladies and gentlemen, I hope I have been able to explain some fundamental characteristics of the rule of law and why we cannot neglect metaphysical considerations. The rule of law, in fact, is essential for self-government and for preserving a free and just society. Experience shows, however, that it can easily be abused for various political purposes, and that we must fight to defend the proper understanding of law if we are to remain free. The Polish people know that freedom must not be taken for granted and that sacrifice is sometimes necessary to defend it. I also believe, this is an important point, that the suffering of our countries, including Croatia, but Poland and other countries that suffered under communism and other totalitarian ideologies, this suffering is a source of great strength that has been lost in the older Western democracies. So, dear friends, allow me to finish with a quote from Father Augustin Kordecki to the defenders of the monastery of the Black Madonna in 1655. He said to the Polish defenders of Jasna Gora, "It may be that God and His Holy Mother intend to blind the enemy on purpose, so that he'd go so far in his lawlessness and rapacity. Otherwise, he'd never dare to raise the sword against this holy place. He didn't conquer this country by himself alone. Our own people helped him. But no matter how low our nation has fallen, or how deeply steeped in sin it might be, there is a limit, which none of our people would ever go beyond. They have turned their backs on their king and the Commonwealth, but they never cease to honor and worship their patroness and mother, who has always been the true queen of Poland. Our enemies understand what is at stake here, and if God hasn't blinded them by design, they'd never dare strike at Jasna Gora, because that day would be the beginning of the end of their supremacy and the beginning of our awakening." Thank you.